Director. All right. And today we'll be talking about balancing ethics and innovation with AI. And this is a very interesting topic for me personally, working for an AI company, a startup in the Bay Area. Caitlin Jones is our speaker for today. She is an experienced business litigation and professional liability attorney. And she'll share some insights and real-world examples that highlight the ethical challenges and opportunities that AI currently presents. And with that, I will hand it over to Caitlin. Thank you, Caitlin.
Wonderful. Thank you, Diana. I'm going to go ahead and share my screen with everybody here. And okay, so welcome everyone. Thank you so much for coming. I think this is a really exciting topic. I know that everybody's writing articles and speaking on AI, and so I think it's great that we're all here to kind of share some ideas and think about how we can use this really exciting and cutting edge technology responsibly in our profession, which is always the goal. I did read actually this morning that this year's TechGC report showed that 65% of the businesses that they surveyed are already using some kind of generative AI platform in their legal department. So that is kind of a bellwether of the direction that this is going. And this is certainly something that's here to stay. So I'm excited to talk to you all about it today. This is my information. If anyone has questions or wants to have a follow-up conversation, this is a topic that I'm really excited about and always like to hear from people what you are using that's working in your practice. So please feel free to follow up with me or ask questions in the chat as we go along. So here's our agenda for today. We're going to be looking at some terms and concepts. I am by no means an expert in the actual technology, but I do want to share with you some common terms. I think that goes to competence as far as being able to talk about and understand the programs that are available. So we'll cover some commonly used phrases and terms. We'll go through some of the main rules of professional conduct that are implicated when we use new technology, especially AI. And then just for fun at the end, I have ChatGPT answer some questions for us. So here's some of the terms that we're going to be talking about today. So first is machine learning versus deep learning. These are concepts that are not particularly new, but they're gaining more meaning and traction in the public consciousness as we all start to use AI tools. We'll talk about predictive versus generative AI, large language models, which are really important to understand because those are kind of the building block of all of the AI programs that we're talking about. We'll talk about chatbots, ChatGPT, GPT-3, 3.5, and GPT-4, so that you all can understand the differences between these terms because it really matters when it comes to using them competently. And then we'll also talk about hallucinations, which I think everybody is aware of and concerned about at this point. So first, when we talk about artificial intelligence, what are we talking about? Broadly speaking, this is just the use of computers to simulate human intelligence. A subset of artificial intelligence is machine learning, which is applying algorithms to data sets in order so that computers can perform tasks that they are not explicitly programmed to do. Traditionally, the use of a computer, every single thing that you could do on it was pre-programmed into the computer, and you really couldn't deviate from that. And machine learning uses algorithms to expand the ability of the computer to perform tasks on its own that it's not programmed to do. We've been using machine learning for years and years now. Some examples would be facial recognition technology, which is just the application of algorithms to a lot of data to identify people. Spam filters are an aspect of machine learning where your computer learns to recognize by patterns what types of correspondences are likely to be spam. Search engine optimization is a form of machine learning. So this is not particularly new. And then deep learning is a subset of machine learning. And this is what we're really talking about today when we talk about cutting edge AI. We're talking about deep learning, which is the use of layered structures of algorithms, which when layered upon one another are called an artificial neural network. And that is designed to simulate the human brain process. And this is supposed to allow the computer to learn on its own, unsupervised, and in fact generate new content. We'll also be talking about predictive versus generative AI. I think these are two of the most important terms to use because everybody's using them all the time. And so it's important to understand what you're working with. Predictive AI, along the lines of machine learning, it uses data to spot patterns and make predictions based on those patterns. This is commonly used in the medical field. For example, an AI platform might look at hundreds of thousands of radiographs and be trained on which ones indicate cancer. By using patterns and predictions and extrapolation, the predictive AI program would then be able to look at a radiograph it had not seen and predict with fair accuracy whether there was cancer present in that radiograph. So that's predictive AI. Things like predictive text on your phone and in Microsoft Word, those are all predictive types of AI. Generative AI is what we're really talking about here today, again, along the lines of deep learning. Generative AI actually uses deep learning to generate new content based on the data that it's trained on. So it's not just extrapolating patterns, it's actually generating content. So what are large language models? This is really important because it's the building block of the AI platforms that we are going to be talking about today. Large language models are a form of generative AI. It's in the field of natural language processing. And they involve the use of artificial neural network architecture called a transformer. And the transformer takes a vast body of text, most of the internet, so to speak. And the text is run through the transformer, which is then able to use statistical relationships and probability to identify the words that are likely to appear close to one another, as well as to give importance and context to those words. So it's a complicated concept, but essentially it's trained on a vast amount of text data to be able to mimic how humans speak by using the probabilistic nature of the way words appear together in sentences and in phrases and in paragraphs. Some examples of large language models are GPT-3, GPT 3.5, and GPT-4, Llama, which was made by Meta, and Palm 2 and BERT, which were made by Google. And these are sometimes called LLMs for large language models. So what are chatbots? Chatbots are a type of AI program that are designed to simulate human conversation. They largely use large language models and they use natural language processing techniques. Some of the early chatbots were Siri and Cortana and Alexa. Now we have Google Bard and ChatGPT, which are fairly sophisticated. ChatGPT, the public version right now is based on GPT-3, which stops at about 2021. So it's an older version. And then some of the more powerful large language models that we're going to be talking about today, which are powering things like Lexis AI and CoCounsel, use GPT-4, which is the most powerful current model that we have. And just for fun, ChatGPT stands for Generative Pre-trained Transformer. So all of those words should have a little bit more context after today. Generative meaning generative AI in that it creates new content or unique content. Pre-trained meaning that it's trained on existing text, and transformer being the artificial neural network that is designed to understand the relationship and importance between words in natural language. Okay, so hallucinations are the thing that everybody should be concerned about and is concerned about, rightfully so. And this is when AI platforms create content that sounds plausible but is incorrect. And when I say it sounds plausible, I mean, they could cite to a case that has the right format of a reporter. It could have the right ear for the type of content that you're looking at. It could sound in every way like it should be correct, but it's in fact completely made up. There's been a few high profile examples of this. Unfortunately, there was a case where a journalist asked GPT to write an article about whether Americans were optimistic about the developments in AI, and ChatGPT actually made up a Pew Research poll and cited it affirmatively for the proposition that Americans were really excited about seeing where AI and GPT was going to go in the next few years. And it made this whole article that was based on a completely made up poll, and the real Pew polling data showed, in fact, exactly the opposite. So it made up a very reliable sounding fact, and it actually relied upon it itself, and that turned out to be completely made up. And then there was obviously the case in New York that everybody's probably familiar with, where the lawyer used ChatGPT to write a legal brief, which contained, unfortunately, completely made up case citations. And that lawyer has, in fact, been sanctioned, and his law firm has been sanctioned as well. So unfortunately, early users sometimes suffer the consequences of not having enough information about how the stuff works. So why do hallucinations occur? Couple reasons. The large language models are trained on the available text, meaning basically all of the text that's available on the internet. That text is written by people, and people are fallible and make mistakes. And so even though the training has ways of trying to make sure that the most reliable text is given the highest priority, that doesn't always happen. So sometimes the model is simply trained on incorrect information. More often, and particularly with the case of made-up citations, it's a limitation in the data set. So there simply isn't a good case on point or a good piece of text that the program can be trained upon. And so it compiles what it's learned about other things to make up something that sounds correct, but is not in fact correct. And then sometimes it comes out of training bias. We'll go through this a little bit later, but essentially the original GPT was trained by human trainers, and people are, they have implicit bias, whether they want to acknowledge that or not. There's a tendency sometimes to give credit to information that maybe the trainer personally believes is true, regardless of whether it is true. And once that bias is kind of embedded into the system, it's very hard to identify it and get rid of it. I find it telling that Jeff Pfeiffer, who's the chief product officer for LexisNexis, admitted that there's no generative AI platform that is hallucination free. So this is something that we're still struggling with as users of AI, and probably are going to see for years to come. And I think it's important to know that this happens so that you can learn how to avoid it. So some programs that are available for the practice of law that we'll touch upon today, and I'm not going to talk about any of these in depth, but you should know that they exist. I really encourage everybody to do a demo of each of these programs. Almost all of them have sales representatives who will walk you through their capabilities. It's a really great way to see if it might be a good fit for your company, and to see if you have maybe a need that you're not meeting right now because you're not using one of these programs. So we've got Lexis AI Plus, or Lexis Plus AI. Case Text and CoCounsel go together. Diligent and Juro are both contract-based AI platforms that may be relevant to those of you who are leading legal departments and are in-house. Disco and Relativity are great e-discovery platforms that have been around for a long time, but have recently integrated AI into their e-discovery platform. And then ChatGPT and Google Bard, for those of you who are brave and want to venture into the unknown a little bit, those are available, and we'll talk about how to use them responsibly. So we're going to go through the rules of professional conduct that I think are especially applicable to using AI, and talk about some of the ways in which we can be more responsible and more ethical users of new technologies. So first is Rule 1.1, and this is the duty of competence. And Rule 1.1 says that a lawyer shall not intentionally, recklessly, repeatedly, or with gross negligence fail to provide legal services with competence. And so when we talk about AI, using AI with competence, I'm really focused on the gross negligence aspect of that rule. And I think that it's safe to say at this point that if lawyers rely upon programs like ChatGPT or Google Bard without doing any supervision or fact checking of the work that's generated by those, that would be probably considered grossly negligent by most who would be reviewing that. So now that we know that they are not foolproof and that they do hallucinate and they have all of these issues associated with them. It simply is incumbent upon lawyers to supervise the work that is produced by these programs if you do choose to use them, and fact check every single thing that they generate. I also think that the duty of competence requires lawyers to know at least enough about the different programs to make an educated choice about whether you're going to use them, and if you are, which one you're going to use. Because as we'll see in a little bit, the capabilities are vastly different, even between GPT 3.5 and GPT 4. Juro does things that co-counsel doesn't do. And so it's really important, if you're going to invest in a program like this, to try it out, get some people at your department who are sort of early users of new technology to try it out, and make sure that you understand its capabilities and its limitations. And the part of Rule 1.1 that I think makes some lawyers sweat is that we are also required to develop and maintain facility with the technology that is used in the practice of law. The rule says commonly used, and AI, I would say, is not yet commonly used in the practice of law, but I firmly believe that it will be within 5 years. I think that legal departments who are not using at least some of these capabilities are going to be left behind compared to those that are comfortable with them. And I do think there will come a period in time when lawyers who have no facility with AI are going to be at risk of not being competent in the technologies that are commonly used. I kind of liken it to the switch from using published reporters in hard copy to using LexisNexis and Westlaw, which didn't really happen that long ago. And there was a period in time when it was acceptable to use books for your legal research and to cite to published cases that were in hard copy, because the new cases were not published until some time later, and so they were still good until they were overruled. But nowadays, where cases can be overruled and we know about it instantaneously, and Lexis and Westlaw are automatically updated in the moment to reflect that, it's no longer competent to cite to a case that you see in a book because you don't know if that case is still up to date without checking. So I think that AI is going to be the same way over time as lawyers develop more and more comfort with it. I think that the firms and the legal departments that don't use any of its offerings are going to be behind the times as far as those who do. So some ways to practice competence in your use of AI and things to be aware of. When you use chatbots, and like I say, it's okay to use them. I think that everybody should explore them and play around with ChatGPT. The answer is only as good as the prompt. So it's really, really important to practice writing clear questions and to practice engaging with a chatbot so that you can begin to understand how the programming reacts to human language. It may not be the same as what you would expect. And you always have to fact check your responses. You cannot trust that anything coming from a chatbot is in fact correct. It may be, and I use them all the time, and sometimes I get really great answers, and sometimes I get answers that are completely made up. If you're using AI programs for contract review and diligence, I know that that is of interest to this audience, so we'll talk about that in some more depth. But the size of your data pool really matters, and the input of the parameters really matters as far as how good the responses are going to be that you're going to get back. And if you're using it for document review and e-discovery, the way that you code the documents really matters. And it's super important to have an attorney do a first level code of all of the relevant information so that the system learns properly what's important as it goes through. If you use a program like Disco or Relativity, they have trainers who will train you how to code documents properly so that the algorithms can do their work for you. So a company called Zuba AI did a test of both GPT 3.5 and GPT 4 on contract review. And I thought this was really interesting to this crowd, especially because it demonstrates the capabilities of these programs for diligence and contract review, but it also underscores the need to really understand the type of program that you're using because their capabilities are so dramatically different. And so it may be competent for you to rely on GPT-4 to do some type of diligence review or contract review. And it also may not be competent to rely on GPT-3 or GPT 3.5 to do the same job. And nobody can really tell you if it is or it isn't. It's going to come from your use of the program, your practice with it, and comparison between the results that you get and a human reviewer. So Zuba tested both 3.5 and 4 on contract review. And they found that GPT 3.5 was able to identify and explain indemnification clauses in a contract as long as the headers accurately explained the content. So it was basically performing a summary function. GPT 3.5 missed indemnification clauses if the header was misleading or didn't accurately explain the clause. GPT-4 identified indemnification clauses in both contracts where the headers were correct and where the headers were incorrect. So it performed substantially better in that regard. But when they asked it to identify change of control clauses, which can be a little bit more complicated, GPT-4 missed 3 out of 4. So I have every faith that these technologies are going to continue to evolve and get better and better, especially when you use a specialized program like Juro or Diligent, where they've used trainers to train on these issues specifically. Those programs may be excellent. But if you're using kind of a baseline large language model, you need to be aware that there can be significant deficiencies in the model. So what are some things that AI can do for people in a corporate world? Document review. It can certainly review and analyze employee records. It's had some pretty interesting and good success with identifying and detecting employee misconduct and issues around morale. It can review outgoing emails or even internal emails and identify words that signify a lack of morale or an intention to remove sensitive documents from the company. So that's one really interesting usage that I think that a lot of companies might find themselves taking advantage of in the future. It can assist in internal investigations and external investigations. And it generally, a lot of these programs do an okay to very good job of contract review. The co-counsel has a different contract platform from Juro. And so, like I said, you're going to want to demo these and see which one suits the needs of your organization. But they can do things like summarize the contract clauses. They can identify market terms and whether your contract is in accordance with the market. They can flag termination and renewal dates for you. They can identify clauses that are illegal in the state where the particular contract is being entered into, and all kinds of things like that. Nevertheless, despite these capabilities, all of these uses require the same supervision and oversight that you would use for any other work that you're doing. And what are some of the abilities of AI in litigation? Document review and analysis. Us litigators have been using AI types of programs for a good long while now, especially things like Relativity, which has been pretty advanced for a while. They're very good at document review and analysis. Lexis AI and co-counsel both have a brief comparison feature that is really interesting, where you can upload your brief and an opposing counsel's brief, and it can give you an analysis of the strengths and weaknesses of the arguments. Legal research, basically all of the litigation-based AI programs are very good at that. ChatGPT, I have found, is hit or miss, and sometimes it does give a pretty good answer for legal research, but I always go back and double check. They do a pretty good job of discovery and document summaries. Co-counsel has a feature where it can prepare you for a deposition. So you can upload all of your documents, tell it what type of deposition you're taking and what kind of information you want to know, and it can actually create an outline for you with lists of questions that are key to documents. So I think that's a pretty cool feature. But again, all of these uses are going to require the same supervision and oversight that you would give to any other task. And so what are the limitations? Obviously, it's got the ability to give you an incorrect answer, and it's sometimes lacks the ability to give you a correct answer. And so the bottom line is it's GPT-4, GPT 3.5, GPT-3 are still not fully reliable. And even OpenAI, which is the creator of GPT-4, put forth a technical paper saying, basically, you should use great care when using LLMs, generated content, particularly in high stakes contexts. So for the time being, that is not going to change. And I think that anybody using any of these programs should be excited and very cautious. So rule 1.4 is the rule that covers client communication. And this is a really interesting question about whether we need to communicate with our clients if we intend to use AI in working their case or in representing them generally. Rule 1.4A2 says that a lawyer shall reasonably consult with the client about the means by which to accomplish the client's objectives. So whether you need to share with your client that you are relying upon AI in accomplishing their objectives is really, I think, a case-by-case scenario. For example, if your use of AI is going to be a significant value add for your client because you're using a program like Relativity to review, hundreds of thousands of documents for you, I think that they would want to know that, that's something that's going to save them time and money, and they're going to want to know why you're able to do so much work in such a compressed time frame. On the other hand, if you're representing an insurance company or an organization, there may be heightened concern about accuracy, about privacy and confidentiality. And so all of those things are things to discuss with your client if you do intend to, for example, submit their confidential information into an AI tool. You'll want to disclose that and discuss it with them. Similarly, Rule 1.6 has to do with client confidences and keeping their information safe. I tend to think that this is an issue that is big right now in the AI world and probably won't be much of a concern within a few years as these programs get better about explaining their privacy and procedures and policies to their clients, those people like us who use them. Rule 1.6 basically says you have to maintain your client confidences and you cannot disclose any information given to you in confidence without your client's informed consent. And this duty extends to information that is stored electronically. The State Bar Formal Opinion 2015-193 reiterates that we have to understand the benefits and the risks associated with technology before we engage with that technology, especially when it comes to putting our clients' information into an online system of some kind where it is potentially subject to exposure. So the different programs really have different implications for privacy. ChatGPT is not private. There is no guardrail, no safeguard in any way. They don't make any kind of assurances that they are not going to use your information. On the contrary, they actually acknowledge that they collect and store user inputted content, and they may or may not use user inputted content to continue to train the model. So you don't want to put sensitive client information into ChatGPT. Other programs like Lexis AI and Co-Counsel will tell you right up front, we do not use your confidential information to train the program, so it is, safe and secure, and it's up to you whether that is sufficient for your use. So as far as taking care to protect and safeguard our client confidences, the most important thing is to use reputable platforms and understand the process that they take to safeguard the information, whether they use it to train future iterations of the model. I mean, any reputable platform, if you do a demo, will be able to answer, what do you do with our confidential information? So they'll tell you, whether they store it, how long they store it for, and whether they use it. It's also important that attorneys be well trained on multiple levels of review, so that if you're using an AI platform, for example, to review company documents in response to a subpoena, that first of all, the coding up front, like we discussed, is properly done to identify privileged and confidential material up front. But also it's important to make sure you have some kind of policy for attorneys to do a second level review to make sure the documents that are being produced are not confidential and are in fact responsive. And a lot of those programs like Disco and Relativity can train attorneys on how to do first and second level reviews. It's also really important that any attorney participating in a subpoena response or an investigation be familiar with the clawback procedures in your jurisdiction, so that if inevitably something privileged is produced, you know the steps to take to claw it back on behalf of your client. So I think in the use of AI, that rules 3.1 and 3.3 are also of paramount importance. And these are the rules that basically say everything that you put forth in a tribunal or a court of law has to have merit, and you have to tell the truth. So rule 3.1A2 says that you shall not present a claim or defense in litigation that is not warranted under the existing law, unless it can be supported by a good faith argument for extension or reversal of the existing law. So if you are using ChatGPT or Google Bard or some type of large language model that's just generally available to the public to write a legal brief for you, or even write a portion of a brief or an argument, it is incumbent upon you to verify that every single thing that you take from that LLM is in fact verifiable, true, and meritorious before you submit it to a court or an arbitrator. I think failure to do that is both potentially grossly negligent under Rule 1.1 and also violates Rule 3.1 in presenting a claim or defense that you don't know for a fact has merit. And Rule 3.3A 1 and 2 similarly says you must not knowingly make a false statement or fail to correct a false statement. And this specifically says you also must not knowingly misquote the language of a book, statute, decision, or other authority. And that's where I think things like ChatGPT are implicated, because misquotes are a known phenomenon. And you have to be really careful that if you do obtain a quote or a source from one of these programs, that you again verify that it is in fact correct. And like I say down here, I think failing to cite check and failing to fact check any kind of generative AI content puts you at risk for violating these rules. Rule 5.3 is the supervision of non-lawyers. And so this again kind of brings up an interesting question, because is AI a lawyer? I think the answer kind of depends and is probably going to change over time. I know that there is much ado over the fact that GPT-4 recently passed a bar exam. So that's I have no doubt that we're going to get a formal opinion from the state bar at some point in the near future about whether we have to tell our clients that we're using AI and whether we have a duty to supervise AI as if it were a non-lawyer. But in short, Rule 5.3 tells us that when we have direct supervisory authority over non-lawyers, we have to affirm that the lawyer, or we have to take reasonable efforts to ensure that the non-lawyer is comporting themselves in a way that's compatible with the professional obligations of the lawyer. And so if you are relying upon an LLM to generate content for you to use in your practice of law, whether it's a contract or a legal brief, in my view, that is content generated by a non-lawyer. And you therefore have the same duties that you would have if that legal brief was written by a paralegal or a law clerk to ensure that every single thing that's cited is accurate and that it puts forth meritorious positions. Like I said, again, I think reliance on generative AI content without human oversight is arguably a violation of this rule. Okay, and so here I think is the real issue. Rule 8.4.1 tells us that we have a duty to avoid bias and discrimination in the practice of law. And this is a real issue that I'm not sure there are good answers to at this point in time. OpenAI, which is the maker of ChatGPT, released a statement explaining that they trained an initial model using supervised fine-tuning. And that means that they used human AI trainers in conversations in which the trainers played both sides. And I don't know if anybody here has ever met a human, but humans are not always great at playing both sides of an issue, especially not a contentious one. So my concern, and I think this concern is shared by OpenAI, and they're pretty open about the fact that this is an issue, is that human trainers import their own implicit bias into the training of the program, which then replicates that bias as it grows and responds to queries from the public. This can come about in a variety of ways, including a tendency to discount facts which the trainers don't like as being, unreliable, while giving too much emphasis to facts that the trainers like. The artificial neural network that forms the basis of these large language models is trained to note the significance of words and not just their probabilistic relationship to one another. And so if human trainers give too much significance to certain words or phrases or ideas, unfortunately, that bias is incorporated into the model. There isn't really a good answer for how to avoid this, except to be aware of it and to make sure that if you're using any of these platforms, you are independently using your best judgment to assess whether the information that you're getting is biased or unbiased. I actually asked ChatGPT why it is biased. And I asked a couple other AI platforms too. And so this is kind of the compilation of the results. And I think it's interesting because it's very unbiased in its answer for why the bias happens. So one of the answers, and this is a summary, I'll go into them in more depth, but one of the answers was that bias is simply present in the training data. So this occurs because the text that the LLMs use to learn on is just text that's available in the world, and it's written by people, and people write things that are untrue, and they write things that are biased and mean, and all of those things go into the model. So sometimes it's difficult for the trainers to catch it, and sometimes it's difficult for the model to understand the difference. Sometimes bias is just present in language itself. It may be that certain combinations of words are used to demean people or create a negative connotation that's not true. But because those words are used together with some frequency, the model finds a statistical significance to pairing those words together, and then it reiterates those words when it is prompted to. And so that's kind of an unfortunate reality of our language, is that language has bias that's just built in, and it's not really possible for us to separate that when we're training these models. Underrepresented viewpoints, like their name, may not be represented properly in the training data, and overrepresented viewpoints may get too much traction in the data. It's a little bit of the squeaky wheel gets the grease problem, where the more prolific a misstatement is over time, the more likely it is to be incorporated into the model. Ambiguous context is a really interesting one. So these large language models are special for their ability to understand context. And that's kind of one of the differences, I think, between predictive and generative. Is predictive isn't looking at context, right? It's just giving you the pattern, what comes next in the pattern. But the deep learning models are able to understand the importance of the words that people use and to place them in context. So these AI platforms can do some really incredible things, like they can write a book in the style of an author because they understand the context of that author's language compared to others. The problem is when the context is ambiguous, the machine basically selects the most probable response. So there are times when the context of a question and answer may not be clear, and the machine is going to simply select the most likely response, whether or not it's correct, whether or not it's unbiased. And then finally is the echo chamber effect. We've all seen this in our daily life with commentary online, but basically as an idea gains traction, it exponentially increases the amount of text that's generated on that idea, whether that idea has merit or not. And the machine is trained on all the text, not just the best text. So unfortunately, it gets a little bit of the echo chamber effect in that the more and more and more a false idea is proliferated, the more likely it is to make its way into the content that the model then puts back out into the world. So those are a number of issues to be really, really conscious of when using AI. And again, the different programs have different value. And if you're using something like Lexis or CoCounsel, you can generally give a little bit less attention to these ideas because they have been especially screened by lawyers to serve the purposes that we need to serve. You still need to look at it, but you don't need to be necessarily as cautious. If you're using something like ChatGPT or Google Bard, you need to pay a lot of attention to whether the content that you're getting is unbiased if you're going to be using that in the practice of law. So just for fun, I asked ChatGPT some questions, including, is it ethical for lawyers to rely on you? And the funny part of this is that it basically says what I've said for the last 45 minutes, which is, it's a nuanced topic. AI models can be valuable tools for research, but legal professionals need to be cautious about how they use them. And I think it's really important that it points out that AI-generated content should not be the sole basis for a legal decision or legal advice. And so the model summed up by saying it can be ethical for lawyers to rely on content generated by language models, but only if used responsibly and in conjunction with their own legal expertise, judgment, and critical evaluation of the information provided. It also reiterates what I said, which is that lawyers need to verify the accuracy and applicability of everything that you get from AI through reliable legal sources. And basically by saying that, ChatGPT is acknowledging that it is not, in fact, a reliable legal source. So I also asked ChatGPT if it can generate original thoughts. And I thought this was kind of a more interesting esoteric thought as we progress in the practice of law and use these types of programs to understand whether it's thinking for itself or whether it's simply a more advanced method of putting words together. And I think it kind of confirmed the second. So GPT told me, as an AI language model, I don't possess consciousness or true creativity like humans do. I can generate responses based on patterns in the data I was trained on, but my responses are limited to the knowledge and information present in that data. While I can generate novel combinations of words and sentences, they are not truly original thoughts in the human sense. So I think this is really important to think about because what we are called upon to do as lawyers is to create original thoughts for our clients, right? To solve their problems and answer their questions. And sometimes that is based on simply looking up the law and telling them what it is. But a lot of times that's based on understanding how things are likely to unfold and giving them the value of our experience and our judgment, weighing different paths forward and selecting the one that is better suited to their needs. And essentially, what ChatGPT is acknowledging here is it really can't do that. And then it goes on to say, any apparent creativity in my responses is a result of the vast amount of text data I have been trained on, which allows me to provide relevant and contextually appropriate answers to a wide range of queries. However, my responses are essentially extrapolations and combinations of patterns I've seen in the data rather than independent creative thought. So once again, you have to know that when you get something from ChatGPT or Google Bard or any of these programs, you're getting the most likely pattern of words that already exist. So it can be really helpful if you want to know something like, what is the state of the law on this subject? Or is this a market contract term? Or is this contract clause illegal in California, right? It's going to go out there and collect all of the relevant text and give you the most likely answer, which is oftentimes the correct answer. But when it comes to, advancing an argument for your client, or, for example, I always think about this is, writing a will or a trust. Can a chatbot write a will for somebody? Almost certainly, yes. It can write a trust. You can give it certain parameters and it will write that document for you. But what it can't do is listen to, the grandmother who says, my 2 grandchildren are fighting, and I want to make sure that everything is left to this one and that this one cannot contest that. And if they do, here are the consequences. That is a real life scenario that it's going to take an experienced estate planning attorney to really parse. How do I write this to make sure that my client's wishes are effectuated all the way to the end? And that's really something that these kind of chatbots cannot do. So they're not creative, and they're not original. They are still tremendous and valuable resources for us to use, but they're not people, and they're not as good as people in a lot of ways. And I like the end, what it says here. It says true creativity, imagination, and the ability to generate genuinely original thoughts are unique human cognitive abilities that rely on a combination of experiences, emotions, consciousness, and complex brain processes that AI models like me do not possess. So to sum up, what are some of the things that AI really cannot do? And I've kind of touched on this, but I think it's important to know when you're using these programs that these are things that only you can do. And, a lot of people say, well, is AI going to take all the law jobs? Are lawyers not going to have jobs anymore? Absolutely not. And I think that where it really becomes evident is the things that AI cannot do. It does not have experience, so it cannot call on the experience of the years to understand a likely outcome. And some people say, well, doesn't it kind of have like the collective human experience because it has everything that we've ever done? No, it has all of the text that's been written, but you don't write every time you have an experience. You don't go put that on the internet. Every time that you counsel a client to a successful resolution, you don't write that down somewhere. Many of those experiences are private. They're not publicly litigated cases, or they're not, published in the news. And most of those experiences are private. And so it simply doesn't have access to that. And that is one of the most valuable things that you have as an attorney. It cannot predict human behavior. I say that with a caveat in that its job is to predict human language, but it can't predict human behavior. So for example, I'm a litigator, I try cases. An AI program cannot take a piece of evidence and tell me what juror number 9 is likely to think about that evidence, because it can't watch the juror in trial and watch her, twitch her eye a little bit every time something is said about that piece of evidence and understand that she really doesn't like what it says in there. It just can't do things like that. It can't behave ethically. So there's a lot of talk about putting ethical and responsible parameters on the development of AI. And I really applaud all of the companies that are at the forefront of making sure that people are doing this responsibly. It does have a code of ethics in a sense, because, for example, you cannot get personal information on there. So you cannot go on ChatGPT and find out where somebody, like you can't find out where someone works, because it has an ethics code related to not allowing people to use it to stalk other people. So there's some effort to put some ethics into it. But what it doesn't have is the rules of professional conduct. It is not in any way required to give you an ethical response, to give you, a moral response. So that is something that is unique to human lawyers, and it cannot behave loyally. It really cannot represent your client's best interests, and it can't advocate for your client. So it can't, so much of the practice of law is listening to your client and understanding their objectives and devising a plan to help meet that objective. And none of these AI programs can do that. So while I think that they are incredible and the technology is absolutely extraordinary, these are kind of the 4 basic things that I think that they cannot and will not ever be able to do. I mean, ultimately, all these programs really do is generate text. And that is just a very, very small part of what lawyers are paid to do. So with that, does anyone have any questions? It looks like we've got some in the chat. Yeah, so Rebecca puts a really good point that we need to keep in mind: privacy protections and concerns about employee surveillance. I assume that that's in regard to using AI to review employee emails and look for morale issues and things like that. That's absolutely true. Depending on where you are, there may be significant concerns about that. In some places, there may not be concerns about that. And certainly after the fact, if you have a departing employee who has left and you have concerns about, theft of trade secrets or misappropriation, some of these programs are really good at identifying transmittals of company information outside the company after somebody's left. But yes, I encourage you to know and understand your local rules about privacy before engaging in any of this. Any other questions or comments that people want to talk about? Is anyone actively using any of the programs that we talked about here? Is anyone using Juro for contract review, Diligent for contract review, Co-Counsel for contract management? Doesn't look like it. I really, really encourage you to get a demo of each of those and see if it would fit. I obviously don't represent any of those companies. I don't currently use any of them on a subscription basis, but I have demoed and used most of them and find them to be really interesting and exciting. So I encourage you to do the same. Okay, Todd says he's used Lexis AI for brief analysis. Yeah, it takes a little getting used to. Much of being competent with these programs is understanding how to phrase your questions and your prompts in a way that the systems can understand and give you the answer that you're looking for. Okay, with that, I'll turn it back over to Diana.
Thank you, Caitlin. I have a question. Have you seen your clients using the generative AI for their customers? So not just internally, but maybe providing services to their customers. And are there any particular considerations to take there?
I don't know. It's not something that I've asked most of them, but I think I'm going to and find out, what they're doing and what their concerns are. I know that we're seeing a dramatic increase in the number of users, and that prices on subscriptions are going down, which indicates, it's catching on more and more quickly. So I think that probably many of them are in fact using, and some of my clients are actually in the field, so using and implementing, for their own clients. It looks like Kevin has a question. Do you think that law schools will begin teaching students on the use of AI? Yeah, absolutely. I think that law is really slow to change, and law professors are probably among the slowest of the lawyers to change. So I think that is a few years down the road. And I think that law students are going to be using it with facility before law professors are teaching it. I've seen it in the insurance arena. I represent a lot of insurance professionals. And there's a few insurance platforms now where people can go buy insurance on an automated basis. Cover Wallet is one example where you can buy insurance without a single human underwriter in the process. And I've also litigated the cases that come out of that because there's no human underwriter to catch the red flags that would traditionally arise in the application process. So it's exciting and interesting and absolutely fraught with all kinds of concerns and problems. Lisa says we have some clients that use an AI program to generate initial discovery and to do MedCron summaries, but with discovery, it usually has to be redone. Yep, I would agree with that.
And Caitlin, on internal use, because we have a policy, not to upload certain types of confidential material for the reasons that you've stated here. Have you seen any methods of tracking and ensuring that that's not actually done? I mean, I can have a policy, but I don't know exactly what each employee is doing.
Yeah, I haven't seen really good examples of it. I do think every company should have a handbook and a policy that discusses the use of AI. Obviously, your IT department can put controls on the use, of those programs, but I don't think that there should be a prevention of using those programs because I do think they have value. So I think it's incumbent upon each company to develop a practice that works for them and has some accountability. I also think that insurers are likely to start asking in the next few years on, professional liability renewals and employment practices renewals. Are you using these types of programs? And if so, are you supervising? And do you have a handbook that, discusses how to use these responsibly? So I think that today is to talk about getting on board. I think everybody needs to get on board and start to understand what we're working with here, because within a few years, it's certainly going to be mainstream.
Great. Any other questions from the participants? If not, thank you so much, Caitlin. That was very interesting and helpful, and we appreciate it. Thanks so much.
Thank you. Okay.